In France, the Council of State is a body of the French national government that acts both as legal advisor of the executive branch and as the Supreme Court for administrative justice. Established in 1799 by Napoleon Bonaparte as a successor to the King's Council, it is located in the Palais Royal in Paris and is primarily made up of top-level legal officers. The Vice President of the Council of State is the highest-ranking civil servant in France. The Conseil d'État, which is also a grand corps of the French state, mainly recruits among the top-ranking students graduating from the École Nationale d'Administration. Composition. A general session of the Council of State is presided over by the Prime Minister or, in his absence, the Minister of Justice. However, since the real presidency of the Council is held by the Vice President, he usually presides all but the most ceremonial assemblies. This is also done for obvious reasons pertaining to the separation of powers. The current Vice President is Jean-Marc Sauvé. Other members of the Council include, by decreasing order of importance, department heads, councillors ordinary, councillors extraordinary, Masters of Requests, Master of Requests Extraordinary, Senior Masters, Masters. The Vice President is appointed by order in Council on the recommendation of the Minister of Justice and is selected from among the Council's department heads or councillors ordinary. Division heads are similarly appointed and selected from among the councillors ordinary. Councillors ordinary, Masters of Requests, and Senior Masters are appointed based on seniority from the preceding rank. Appointees from outside the Council may include administrative law judges or may come from outside the justice system. Masters are recruited from among the graduates of France's National Administration Academy. The Council sits in the Palais Royal located in Paris. The Council is divided into 7 divisions. Administrative claims, see below. Report and studies. Writes the annual report, conducts studies and helps to oversee judgments and verdicts are carried out. Finances, the interior, welfare and social security. Public works and administrative issues review any and all cabinet-issued orders and statutory instruments and examine and sign off on all orders of Council. These reviews, though mandatory, are not binding. The Council of State also studies legal issues and problems brought before the Cabinet. In addition, it is responsible for carrying out administrative court inspections. History. The Council of State originates from the 13th century, by which time the King's Court had split into 3 sections, one of which was the King's Council, which too broke up into 3 distinct parts: the Conseil Secret, Privy Council, the Conseil Privé, Private Council, and Conseil des Finances, Council of Finances. Reorganized under Louis XIV into 2 major groupings, it was the Conseil d'État Privé. Finances, a direction that was the direct ancestor of the Council of State. It brought together legal advisors and experts to advise the king on claims against the crown. Officially established in 1557, this was the largest of the king's councils, made up of France's High Chancellor, Lords of Peerage, Ministers and Secretaries of State, the Controller General, 30 Councillors of State, 80 Masters of Requests, and the Intendants of Finance. The judicial portion of the council was known as the Conseil d'État Privé or Conseil des Parties. The kings, who had the power to dispense justice and hand down judgments as the court of last resort, delegated this judicial power to royal courts and parliaments. But the French king still retained the power to override them at will. Specifically, French kings maintained their privilege to decide major issues and hand down judgments when administrative acts were in dispute. The judgments of the King's Council of State were regarded as being issued under the king's residual proper jurisdiction, that is, the sovereign's reserved power to dispense justice in certain matters. Legal advisors also assisted the king in developing new laws and, by delegated jurisdiction, directly exercised sovereign rights. For more on French government administration during the Old Regime, see Ancien Régime in France. The current Council of State was established by the French consular government in 1799 as a judicial body mandated to adjudicate claims against the state and assist in the drafting of important laws. The first consul presided over council sessions, and the council performed many of the functions of a cabinet. After the Bourbon Restoration, the council was retained as an administrative court but without its former prominence. Its role was more precisely defined by an 1872 Act of Parliament. Advisory role. Certain types of statutory instruments must be examined by the Council and receive its advisory approval, including all draft legislation proposed by non-parliamentary members and prior to being introduced before Parliament. Orders in Council. Signed by the Prime Minister and Cabinet Ministers, any such order is a form of delegated legislation outlining how a statute or Act of Parliament is to be carried out or put into effect. Typically, a statutory law will authorize, prescribe, or prohibit an action defined in broad terms and require a government order to define its scope and application. The Council's advisory workload is divided between its administrative sections with respect to the ministry or department affected by the government order. Administrative justice. The Council acts as the Supreme Court of Appeal for administrative law courts. It hears both claims against national-level administrative decisions and appeals from lower administrative courts. The Council's decisions are final and unappealable. While strictly speaking the Council is not a court, it functions as a judicial body by adjudicating suits and claims against administrative authorities. Plaintiffs are represented by barristers drawn from the senior court bar whose members are licensed to argue cases before the Council and French Supreme Court. Any such barrister bears the title of counsel at senior court. Original jurisdiction. The Council hears cases against decisions of the national government, e.g., government orders, ministerial rules and regulations, judgments handed down by committees, commissions, and boards with nationwide jurisdiction, as well as suits concerning regional and EU electoral matters. The Council of State evaluates how well regulations and administrative decisions comply with higher sources of law, i.e., the Constitution, higher administrative decisions, the general principles of law, statutory law, and international treaties and conventions. Much of France's substantive administrative law is not codified or laid out in statute form, but instead derived from administrative case law, primarily by the Council. The Council has full discretion to adjudicate on the legality of any executive branch decision except for the very narrow category of active government, for which it considers itself forum non-conveniens. The Council has judged that such acts are restricted to relationships between the executive branch and the legislative branch, e.g., whether a bill should be submitted to Parliament. Acts that are part and parcel of France's foreign policy. In this role, the Council provides a powerful check on the actions of the executive. Appellate jurisdiction. The Council of State has appellate jurisdiction over local election judgments from any of the 37 administrative courts. It has final appeal jurisdiction for decisions originating from any of the 8 appellate administrative courts, meaning that it hears cases in which the plaintiff argues that the appellate court ignored or misinterpreted the law. Court procedure. Like nearly all French courts, the Council's court system is inquisitorial, and proceedings are initiated by a statement of claim detailing the factual background of the case and why the appellant should be granted relief. The Council then begins a formal investigation, asking the appellee, i.e., the government or a government agency or office, to satisfy the Council with a detailed statement of defense. Burden of proof does not lie with the plaintiff. Instead, the Council decides whether or not the appellant has cause to bring suit and whether the government was in error if information provided by the appellant is sufficient to locate previously undisclosed evidence. Of course, both parties may submit additional pleadings and information until the case is ready for final judgment. The formation of judgment depends on the importance of the case, for the jurisprudence and the interest of the law. All of the formations belong to the Administrative Claims Department. The small cases are treated by one underdepartment. There are 10 underdepartments. The bigger cases are for the United Underdepartments, concerning 2 underdepartments. The more important cases are for the Administrative Claims Department judgment formation. Only the very important cases, with hard, new and important legal issues are concerned. There are about between 20 and 40 cases per year in this high formation. This formation concerns the president of the 10 underdepartments, the 3 assistant presidents of the Administrative Claims Department and the president of the department. The major cases are resolved by the Administrative Claims Assembly. All the presidents of departments are there, under the presidency of the Vice President of the Council of State. Less than 10 cases per year are concerned. All the cases, even the ones eventually resolved by the Assembly du Contentieux, are first studied by an underdepartment. Although the procedure is written, one of the highlights of the judgment is the oral conclusions of the rapporteur public, giving his personal vision of the case, totally impartial and free, on a pure legal point of view. The reading of the old conclusions is often useful to understand the mind of the judges and the reason of the solution given to the case. Since an order of 2009, there is a possibility to speak after the rapporteur public. The lawyers use this possibility only for the major cases, when it is really useful. In some cases, there may be some confusion as to whether a case should be heard before an administrative law court or judicial court, in which case the Court of Jurisdictional Disputes, or Tribunal des Conflits, sat by an even number of state councillors and Supreme Court justices and chaired by the Minister of Justice, is convened to decide to whom the matter shall be vested. Major rulings of the Council of State exercising judicial review over almost all acts of the executive branch. The Council of State's judgments may be of considerable importance, often not for the actual case judged, but for its importance in shaping legal interpretation. While France is a civil law country and there is no formal rule of precedent, lower courts follow the jurisprudence constant doctrine with regard to the Council of State. The Council's major rulings are collected into law reports and commented on by scholars. The Council's official website carries a list of comments on important decisions. The Council has shaped its own legal doctrine, which consists mostly of principles deduced from cases but incorporates considerable jurisprudence derived from statutes. Rulings are named for the moving parties in the cases and under highly formal courtesy titles. Men's names used to be preceded by Sieur, women's names by Dame or Demoiselle, and widows were referred to by their husband's name Dame Veuve. About 10,000 rulings per year are given by the Council of State. The most important rulings are collected in a publication called GAJA, published by Dalloz Editions and written by some of the most influential authors or judges of the time in France. The GAJA explains about 120 rulings, from 1873 to now, and quotes several hundreds of other important rulings. Important rulings include February 19, 1875, Prince Napoleon. The fact that a decision has been taken with political considerations does not make it an active government that cannot be adjudicated by the Council. A prince had been removed from the army for political reasons. The Council stated that his case had to be heard, but then decided that it was unfounded because the law said that his commission could be revoked. May 28, 1954. Bell. Freedom of opinion of civil servants. After a number of communists had been refused admission to the École Nationale d'Administration, it was decided that the government cannot exclude people from applying for civil service positions solely on the basis of their political convictions. October 19, 1962 Canal. Robin and Godot. The executive branch may make decisions by ordinance only within a narrowly defined scope authorized by the enabling law. The executive cannot mandate the creation of courts whose procedures and lack of recourse fall outside the general principles of criminal law. This decision was the source of tensions between the Council and then-President Charles de Gaulle. February 3, 1989 Alitalia Corporation. The executive branch is responsible for voiding its own unlawful rules and regulations, even if they were initially lawful. Regulatory law must comply with European Union directives in force. October 27, 1995 Commune of Morsange-sur-Orge, also known commonly as the Dwarf tossing case. Respect for human dignity is to be included as part of the ordinary public. In this case, a mayor had prohibited a dwarf tossing event on the grounds was against the public interest, because it did not respect human dignity. This decision stops short of including morality as part of the ordinary public. March 3, 2004 The asbestos case. The state may be held responsible for not taking appropriate measures, in accordance with current scientific knowledge, to safeguard workers' health, even if workers are employed by private employers. French Institute of Administrative Sciences. The Council of State is linked with the French Institute of Administrative Sciences. The Vice President of the Council of State is the President of the IFSA, and its main members are state councillors. In 2009, the Council of State hosted IFSA's annual conference, which was organized on the theme, Public Security.